and I see that the chair is also just walking in, but he can't participate anyway. So, so these two names ring a bell. So the two names are the two judges at the ICC, the Ugandan judge at the ICC, and the Benin, Alapini is the Benin judge at the ICC. When I was asked to speak, I was asked to, because colleagues who are with me here will be speaking more about specific countries and the continent, I was just asked if I could just give a few case studies from other parts of the globe in terms of judicial independence. And the reason I start with Judge Bossa and Judge Alapini is because there's something extraordinary happening about judicial independence that is actually quite scary. And on June 5th, 2005 and August 20th, 2005, Trump designated a total of 6 judges of the ICC and sanctioned them. Those are Judges Alapini, that I just talked about from Benin, Judge Bossa from Uganda, and there are 4 other judges, one from France, one from Slovenia, one from Canada, and the last one, I believe, from Peru. And what the sanction says is that these individuals cannot deal or are not allowed to go to America. American institutions can't transact with them. And what that means, just to give an example, is if you do a wire transfer from anywhere in the world, it's likely going to go through an American bank. Even if you're sending money from here, Nairobi to Nigeria. So a judge of ICC today may not be interested in going to the US, but they may not be able to transact just simple transaction, money transaction. Trump also has designated a judge called Judge Moraes from Brazil. Why? By the way, I should have said the 6 judges are designated because of issuing warrants or participating in the situation of Palestine, Israel and Palestine case, and also participating in the situation of looking into the American military activities in Afghanistan. Judge Moraes from Brazil has been sanctioned under a different scheme. It's called the Magnitsky scheme. And the reason he's been sanctioned by Trump is because, as most of you would remember, after the 2022 Brazilian election, Jair Bolsonaro, the former president, tried a Trump type January 6th. And so he's being investigated by that, and Judge Moraes is dealing with that case. Not only is Judge Moraes designated, and by Trump is very clear, it's because of looking into the situation of Bolsonaro, who is his friend, but his wife now has been designated. So that's the first case study. What does that do to judicial independence? We have 2 judges, active judges. We have quite a few other people who act in the judiciary or tribunals, and some who are aspiring to be judges. If, judge, you are told that you cannot get your visa to the US because if you have dealt with a case, or you might be dealing with a case that goes in one way by Trump, does that affect your judicial independence in Malawi or in Lesotho, for example? So that's the first case study, just to show you the complexity of judicial independence we're talking about. I want to go to the second, because I don't have much time, and I had 3 case studies I wanted to just put across. Mexico. In Mexico, they've just passed a law that all judges will be elected. And all those judges, all judges, and the elections have to be renewed every 9 years. Before that, the judges were appointed not so differently from how we appoint judges, recommendation by Judicial Council, and then a confirmation after, I think, 3 years by the 3 to 6 years by Judicial Council, and then that is for the term, for life basically, or at least until they're required to retire. Now they have to go through elections. It's not just elections. Their elections are timed at the same time as the political and legislative elections. The Judicial Council itself has to be elected through a full political process. Again, what does that do to judicial independence? The last case study, Poland. In 2015, a government led by a party called PiS, and this is not a joke, it's P-I-S, PiS, took over and started making significant judicial changes to two of their key judicial institutions, the Transition Council and the Supreme Court. For those who understand the civil law jurisdiction, civil law always have constitutional councils or constitutional tribunal. In this case, they have a constitutional tribunal. Constitutional tribunal are the political courts. They deal with political issues. But still, in most jurisdictions, they are protected like judiciary, and even the processes of their appointment is protected the same way you protect the judiciary, because they deal with significant and serious issues. So for example, in Poland, they deal with issues of constitutionality, issues of competence between different parts of government and such. So PiS comes into power and decides that it wants to attack the judiciary because the judiciary is too radical and difficult to work with the political class. And so starts making reforms which allows for Parliament to take hold of the appointment process. They fire judges who are in the Judicial Council and replace those judges with their own judges who are friends. The President actually appoints judges to the Transition Council initially, including the Chief Justice, who are political operatives of PiS. And then at the Supreme Court, and the Supreme Court is similar to our Supreme Court in many ways. It's a final court of appeal, civil, criminal, and other matters. They take over and fire all the judges again who are part of the Judicial Council and introduce their own judges. These new judges are actually given because they sit in different benches, they are assigned to an extraordinary bench, which reviews what other benches of the Supreme Court do, especially on political issues. Luckily, in and by the way, Poland was a very interesting case because this was litigated at the EU Court of Justice, it was litigated at the European Court of Human Rights. Both courts found that this was significant interference with judicial independence. But what I found most interesting is at one point, judges from all EU countries went to Poland and joined other judges in a public demonstration to protest on judicial independence. But anyway, luckily 2022 a new government comes in, which is Liberal. But they start trying to then go back and claw back all these negative reforms on the judiciary. But why I bring up Poland case is the difficulty when you have already messed up with the judiciary, the difficulty of trying to fix it. Because currently, Prime Minister Donald Tusk, he's another Donald, but this is a good Donald, has been trying to reform by making the judiciary independent. But remember, Parliament already had got a lot of powers. The President has veto power. The President is still from PiS. And so when they try to introduce reforms, the President vetoes them. or the president refers them to the the Constitutional Tribunal, which is full of peace appointees. And so now, in Poland, the current government is trying actually to circumvent the rule of law to be able to bring about changes. I'll just give maybe 2 examples of those. One, for example, there is a requirement to publish judgments for them to be enforced. Because the Prime Minister is in charge of the executive arm, he refuses to publish judgments that go against the government or that they don't like. So for example, but then publishes the one that he likes. So there was an electoral contest judgment for parliamentarians in 23 that favored his party. He published that. But then other judgments that talk about the composition of the Constitutional Tribunal, he refuses. So you can see the tension. Second example, and the last example, is they had changed laws on abortion to align with the very American now approach to abortion. But then the Liberal government comes in and wants to provide for right to abortion. But if they try legislation, it's going to be vetoed by the president, right? Or he will refer it to the Constitutional Tribunal, and it will fail. So what is the current government doing? It just publishes guidelines for doctors on how to procure safe abortion. It just tells you how messy it is. I just want to end with this comment, which I think it's fundamental in terms of thinking about judicial independence. That identifying the erosion of judicial independence is not necessarily a self-evident task. Akin to other forms of constitutional abuse, reform to structure and powers of the judiciary is often draped in the cloth of democratic language. Those who went through BBI know about the introduction of a judiciary ombudsman. It looked like an appealing provision for judicial accountability.
Moderator, I think it's for a reason that we sat on the extreme ends of this panel, because I want to take another perspective. Judicial independence and judicial accountability are very inextricable. 2 sides of the same coin, they say. And I'll be focusing on the Kenyan situation because I sat for 5 years in the body that is mandated to promote judicial independence and accountability. And of course, I have the lens from which now I view the two. They are both important. In Kenya, from where I sit, I find that judicial independence had been very critical, and Mr. Wiper, don't get me wrong, it was a wild horse out there in the 80s and in the 90s that we managed to get. Things were bad. We all know that we used to see judges, we don't know how they were recruited, we don't even know who they are. There's a story of a certain advocate who was saw policemen coming, he was hiding in his village home. Then he sees policemen, he runs to the plantation. I won't say whether it was maize or tea, lest you start guessing who it was. But he runs to the plantation, and the police officers run after him and they wrestle him to the ground. He wants to run away. Then they tell him, please don't run away. We've been asked to take you to State House for swearing in. So that's that, and it's a true story. It's in, I've included it in an article that I wrote on in one of the journals that Protas Saende should read now that he's preparing to go for the interviews. But those days are past. At least now we know, and the reason why they used to do that is so that they get you, they get the bad ones. Then you see, if you have a lot of skeletons in your cupboard, then you have to do what they say. we've come a long way. We know Prota signed there has an interview date with the JSC. We know Priscilla there has an interview. You know people that you know and see. So as far as, yes, and Hassan here, as far as independence is concerned, I would say that that horse is in the stable. Granted, the stable has a lot of breaches around the wall, so we need to keep vigilant. But lest it escapes, yeah, whether it's about financial independence and other aspects. But the same energy that we had in the 80s and the 90s towards judicial independence, I think should now be directed towards accountability. That's very same energy, and this is why. First and foremost, we were told by the good judge there that corruption is everywhere, it's even in heaven. He gave us an example. I'm quoting the judge. And so because of that, that's where the devil came from. Because of that, we need to be vigilant, yeah, because there is an accountability deficit everywhere, in the bar, in the legislature, of course in the executive, but also in the judiciary. So we need to focus on that. Then secondly, there's a trend that really concerns me, and the Vice President, I think, was referring to that particular example that I was giving in a presentation I made at the LSK conference in August, that there's a very dangerous trend where we know that when a judge has violated, has allegations on misconduct, has done something that violates the code of conduct, we know the process in the Constitution, in the regulations by the JSC. But what has been happening is that when a judge is taken before the JSC, and I'm sorry to say, including even the Chief Justice and the Supreme Court judges, what they do now is to rush to the courts to get conservatory orders to insulate themselves. So this self-insulation for me is really, really concerning, because what does it say? It says we are infallible, we are stonewalling ourselves, there is nothing that you can do about it. You know, in Kenya there is a phrase that we use, mutadu, and you see that can really be exasperating, and it's a dangerous trajectory. So that is the second reason why I think that even as we watch so that the wild horse does not escape of independence, our energy should be on accountability. Thirdly, we have a problem with our socio-political organization. Yeah? Zaja, what are we? We are supposed to be a constitutional democracy. Do we have an opposition? There are many people who think Victor Diambo here is the leader of opposition, because that's all we see. Our position was married away, it has been taken away. So we have no one to shadow what the executive and even the legislature does. And that's why you find a lot of issues that would have been managed in a situation where you see corruption is everywhere, even the microphone is being corrupted. So in a situation where we would have had an official opposition play its role, we are finding those issues now going to court, whether it's about SHA. I don't know how to explain what SHA is to those who are visiting from other countries, because we also don't know. But it's something around health, a kind of a health insurance that doesn't work. We have something called affordable housing. We have bills that are passed, but because we have no official opposition, you find that the judiciary now is the final bulwark, and Kenyans look to it, and unfortunately to a large extent, it plays the role that an official opposition would actually be playing. And for me, that is, it's so important for us to have an accountable judiciary, because of the situation that we have found ourselves in, with a dysfunctional democracy, or maybe democracy sui generis, to be kind to them. Then the second last point, you know, when you sit next to the moderator, you see him shifting, you think, oh, am I talking for too long? There's the issue of the public confidence in the judiciary. You see, it is proportional to the level of accountability. I love an article written by Janet Liabunya, a Malawian. I hope to meet her one day. And she says that where there is no public confidence, or where there is low accountability in a judiciary, she was referring to the Malawian judiciary, people normally resort to what she was calling popular justice. Now, popular justice is totally different from alternative justice. Popular justice, by the way, all intents and purposes, is mob justice, you know, vigilantism and the like. And we already have it, you can sense it here in Kenya, that we have a judge on TikTok called Judge Jackie. And many people go and take their cases there. They are hard and determined, and they have even witness protection. I follow those cases once in a while, and I wonder, where are we heading? Who has heard of Judge Jackie? She's not appointed by the Judicial Service Commission, but she's a judge nonetheless. Now, that is popular justice, and for me, it speaks to the level of confidence, or the level of confidence, and I think it has to do with accountability. The Justice Needs Survey in the country, the last one that was done, recorded that only 20% of Kenyans approach our courts. Mr. Hassan, even as you seek to join them, and I wish you well, only 20%. And I had a discussion with the CJ, Honorable Komen. She was telling me when she was being appointed as the CJ, and the reason why she came up with the social transformation through access to justice was she was asking herself, will I be a Chief Justice of only the 20%? What of the 80%? And then she came up with this multiple door approach in her blueprint. So that is concerning. So when we have low levels of accountability, then it is concerning, especially now that we know we are always campaigning, we are always in an electoral cycle, but even as we approach the general election in 2027, an accountable judiciary will be very, very critical. And then finally, I would want to say that an accountable judiciary is so easy to defend. Yeah, it is so easy to assert their independence because people can fight for them. People will always stand up for something that is accountable, whether it is from the executive or the legislature or wherever it is from. Remember, in 2019, and this is the last point I'll be putting forth at this juncture. 2019, we had a time when 4 judges, the executive refused to swear in 4 judges. And we all knew, I can mention their names now because they are now safely in the Court of Appeal. So the problem with the executive was having them move on to the Court of Appeal. And it is because 2 of them had sat in the BBI panel, that is Justice Ngugi, I believe, and Justice Odunga. So they were saying these people have adverse, we have adverse reports against these 2. So they are unfit to become Court of Appeal judges, never mind that they were already High Court judges and nobody was petitioning for their removal. But I remember the entire country rallied around those four judges. Anyway, the immediate former president remained unmoved. They were only sworn in when the new regime came. At least that's one good thing the new regime has done. But what I am trying to say is that when we have an accountable judiciary, it is so easy for people to stand, because people would say, we know Justice Odunga, we know his ways, we know Professor Ngugi, we know his ways, and the other 2. So what I would conclude by saying that even as we are comfortable that these wild horses there, and we will be vigilant, we really need to focus on accountability. Yesterday, Jedida Wakonyo asked me, how come there are no Kenyan judges here? I don't know. I'm not a member of the executive board. I don't know why they're not here, and it doesn't mean that I would have attacked them. But it is good to have these healthy conversations, especially against self-insulation. And by the way, self-insulation is not only through court. Those of you who watch news saw that the lawyers in Maua, Meru, were so discouraged because of a certain magistrate who was misbehaving. So they had demonstrations. And what does KMJA, Kenya Association of Judges and Magistrates, do? They released a statement, you know, like trade unions. I'm a university lecturer. We are just coming from a strike, an over 50-day strike. But you see, that should not be heard amongst the judges and magistrates. I'll stop there for now, moderator. Thank you.
Thank you so much. We'll get back to
Mawatwenim, some of you have come to know that it means mother of monkeys. So if your totem is a monkey, I'm your mother. I joined the judiciary 3 years ago, having been a practitioner probably for 2 decades or more. I came here probably to tell you about the judiciary of Lesotho. I'm of the view that when people look at Lesotho or Basotho, generally they look at Lesotho as, you know, that boy in your high school class who sits at the back and you don't know anything about him, or you know a few things about him. You know that he comes from a poor family and he lives, but his house is in the suburbs and surrounded by rich neighbors. And for him to go to school, he has to go via the rich neighbor's house. And he depends so much on that neighbor. But nobody knows what's going on in the house. But they see this boy waking up every day, going to school, being their classmate, and passing with them. But nobody really wants to know what is going on with this guy. That is us. That is how most countries view us. They say, there's a small country in Lesotho, totally surrounded by South Africa. And some people have even said, why are they still existing? Our sense of sovereignty, it becomes such a big question. Who are they? What? And today let me share with you the beauty of Lesotho. We have similar problems. If I were to tell you about our problems with judicial independence, you'll realize that we had the same colonial master. He did the same things that he did to you, and we share the same history, basically. Manifestations might differ, but most of us have had a four-man Judicial Service Commission, manned by the Chief Justice, Secretary being a registrar, and so on and so forth. We still have that. Most of us have had either a strong executive or a strong legislature overpowering the judiciary. We had that. Now the question is, are we still there? Now that small boy, or that boy who sits at the back, most of the time what he does is that he looks at all the loudmouths and learns from them. And this is basically what we do. We look at all of you, busy thinking that we don't exist, or not caring, or just being curious. And we learn from you. We learn beautiful lessons from you. One of the lessons we've learned from watching other jurisdictions, we had problems. Our Achilles heel was politicians, the legislature. They realized, when they woke up in 1993, when we had a constitution, they realized that they had so much power in the appointment of judges, especially the heads, the president of the Court of Appeal and the president of and the Chief Justice. So they used this to isolate the two heads of parliament and make them semi-politicians so that they can control the courts. We also had issues of appointment of puny judges, like everybody else. We all been there. And we realized that all these issues of appointment and issues of the heads of, even ICJ had to come to Lesotho and intervene because our two heads of judiciary were fighting, like literally fighting over who's the head of the judiciary. Why were they having a fight? Because it was convenient for politicians to say, we want the Court of Appeal president to be the head of the judiciary because we can control him. Whether it's true or not, I don't know. But the ICJ came and intervened, and they found that something is amiss. So we've been through these problems. But as that boy was sitting there at the back was saying, oh, so this is how we can solve our problems. This is how we can solve our problems. So the judiciary did a self-introspection and did an inward-looking position and said, how can we get away from this? We can't, because the composition of the JSC is retrenched, the 4-member panel is retrenched, but they said, hey, we're Moses, what do we have in our hands? Oh, so we can self-regulate how we appoint our judges. Okay, how is it done? We looked at South Africa, we looked at Kenya. Oh, so we can actually have public interviews. So we can add the secrecy of having judges being selected while they're at their field and they think that they're going to be arrested. So we went through the process in 2021. Yes, we're latecomers. But what am I saying to you? The boy who sits at the back is learning, and is learning quickly. We might look like slow learners, but we're not. We're careful learners. We want to analyze, what is Kenya doing? Oh, since 2010, they've been doing this. How is it faring for them? It looks like they had problems here and there and there. Oh, so they flooded with academia and it didn't turn out good? Okay, so we shouldn't go that way. What is South Africa doing? Oh, so they had politicians, and yes, Malema thinking he can appoint judges. Nah, not good for politicians to elect us. You know how snobbish we are as lawyers. So if you're going to have some politician, and our politicians are not many of them are so educated. So if you're going to have a matric person, or a Form 5 person in our case, intervene you to a position of a judge, there's something there for us, for that small boy sitting at the back. So what did we do? We self-regulated, and we had interviews, and we had procedures. The JSC had procedures that how they could appoint judges, and this is how some of us became judges. I wouldn't have become a judge if it was not of that. I used to be politically active. But the JSC said, so what, you're politically active, but you're a good lawyer, and you want to be a judge. You have applied. Here are the things that we want, here are the prerequisites that we want you to have. And if I passed that, I passed and became a judge. So we want the judicial independence and appointment. Impeachment has been used as a political weapon by the executive, because the prime minister, yes, has powers to recommend to we are a monarchy, to recommend to the king that, oh, so-and-so is misbehaving, so I want you to remove him, especially the two heads, the president and the CJ. So the prime minister has the power to recommend to the king that the JSC should recommend a tribunal to fire a judge. We've all been there. I'm sure some of you have this, except you don't have a king. Lucky us, we do have a king. Tina's name goes, something that you all miss. I wish you did. Anyway, that's us in Swaziland. We're better off. So we realized this, that, you know, the JSC, what the JSC did from 2020, from 2019 probably, is to say we can't just sit and wait for political or constitutional reforms. We have to do something. So what they did is they learned from all you. And they came up, in 2025, we came up with a code of conduct for judges, so that impeachment is not the only way that judges can be removed. The code of conduct outlines the misconduct that a judge should face in the event that he has to be removed. The jury is still out on whether these are effective or not, but we're watching all of you at the back. And as I listen here, I'm going to take lessons home and say, Chief Justice, this is what those people are doing, and as I was sitting at the back, this is how I think we can refine our judiciary. So we have judicial accountability through the code of conduct. We have provisions like the 90-day rule, where judges have to produce a judgment after the 90 days after reservation of judgment. It was a directive when we joined the judiciary. Now it's in the code of conduct. So we're learning all these things from you. We stole that from Nigeria, I think, and also from you guys, and Zimbabwe, the 90-day rule. So there's good things happening. Am I saying this because I'm part of the judiciary? I hope not. And in my heart of hearts, I don't think so. And this is why I so much wanted to be the judiciary, because I wanted to be part of the change. And I'm glad that we are getting somewhere. Thank you.
It's difficult to come after a judge because I don't know what to say anymore. But first of all, can I just thank the Council of the ICJ for making it possible for me to join this. I've never been in a room with so many jurists, you see. But in saying that, can I also apologize? I checked in about 5 hours ago after traveling for 2 days. So if I am entirely inarticulate, please don't take it too seriously. I'm not responsible for anything I say this morning. Sorry, I saw somebody wondering why traveling for 2 days. I came in from Boston. So that's the explanation for that. Let me, maybe I'll start with a story, because everyone here has provided, on this panel has provided a perspective. I'm going to try and banalize the conversation if you permit me. In 1884 actually, there was a man, German, Karl Peters. Karl Peters started off the German colonial society during the tenure of Otto von Bismarck, with a mission of trying to get Germany interested in colonial acquisitions in Africa. And Karl Peters was a white supremacist who believed, amongst other things, that white people should not mix with blacks. In 1891, Karl Peters was appointed as the Reich Kommissar for Kilimanjaro across the boundary in a country that is presently in the news. And as Reich Kommissar, who was a white supremacist, he kept sex slaves, African sex slaves, for the enjoyment of himself and the troop of a few hundred German men who worked with him. And he kept a mistress. For those who know the history of Tanzania, her name was Jagoja. In 1892, he discovered that Jagoja, while he was having a relationship with her, also was a nationalist. She liked to have her African men. This Muzungu thing was okay, but not good enough. And when Karl Peters found out that he had African competition, he was distressed, and his German manhood was challenged. And what he did next was to use the judicial system. He invited a German judge who tried the man and sentenced him to death for being his competition, and he had him hanged. Jagoja, finding this out, ran for her life, as she was wont to. He tracked her down, and in July 1892, had her tried and hanged. Now, this story is about what? Rule of law. Now, this German rule of law had, because it's interesting, we've heard about judicial accountability. And I want to borrow a leaf from Waikwa's opening. Because when this information got to colonial Germany in 1892, there was outrage at the use of the legal system and of judges for this purpose. As a result, in 1893, an inquiry began. By 1893, Karl Peters was recalled, and by 1897, he had been discharged from the German colonial service for these abuses. Ultimately, of course, if you follow the story, Kaiser Wilhelm II had him restored shortly in 1914. But the question I have is, if this happened today, will the politician who procures the judiciary for this purpose be held to account? Will the politician lose their job? Because if they don't, we do have an issue. And Waigwa was visionary in in his presentation, and we've heard the same from her leadership and from Dr. Deche. And as I said, I want to be quite banal. So I start with the story of mistresses and sex. And in doing that, I want to pose 3 issues at least. One is our understanding of judicial independence. Epistemic issues. What does judicial independence mean? And on this panel, we've got at least 2 former law teachers, probably 3. 2 former law teachers and 2 current law teachers. Now, we teach our students about judicial independence in administrative law, constitutional law, legal system. You can't go through a law faculty without being obsessed with judicial independence. And we teach it from, and rule of law, of course. How do we start the story? We inherited it from the British. Isn't that the story? It's, and Robert Ray and folks like that, who told us that it was one of the legacies of colonialism. How could colonialism give you independent institutions? How? From where? Colonialism was ruled by the thumb of white folks. That means what? You could never have had independent judiciary from colonial rule, because colonial rule was based on the idea that judges were procured to do things that they were instructed to do. And all of those elements that we have, that we teach about judicial independence, particularly the independence that is tenure protection. They never had. As a matter of law, colonial judges did not have tenure protection. However, because we taught and continue to teach our students, and it's not just that, I could say other things. We teach rule of law with judicial independence, and we start from where? A.V. Dicey. Isn't it? A.V. Dicey wrote his book, his famous book on the law of the Constitution, when? 1893. 1893 was exactly the time that his foes were massacring people all over Africa, treating all of us like we were not human beings. We do not tell our students that A.V. Dicey's rule of law was inapplicable to our African spaces. But we teach him with no sense of accountability, intellectual, moral curiosity to ourselves and to our generations. And so, there is a pedagogical challenge. That's where I begin. And that's where I suggest we start this. What is our pedagogical approach to the teaching of law and of institutions and of judicial independence? Because if we don't address that, we are being situational and convenient. We've got to take responsibility. That's the first question. The second issue is institutional culture of the judiciary. Where do we get the people we appoint from, and what do appointment practices look like? Institutional cultures are very important on these issues of independence. And those institutional cultures, even with a country like Kenya, where you've broken the back of the old system, and Kenya deserves a lot of congratulations, and Kenyans do, for the 2010 constitution, and see how long it took. to come to 2010 and see how many dead people it took to come to the 2010 Constitution. But we're here now. That history, though, is important. And that history teaches that institutional cultures do matter. And the institutional cultures are not events. They are built over time. How do we appropriate those for encouraging progress along the path of greater independence? And the history of the 2010 Constitution is something else. So having started from where I started, which is what? Judicial independence is a matter of political culture. And political culture is built over time. Because we started off telling ourselves that we had inherited independence from white people, which could not have happened, we lost an opportunity. This country only started building independent judiciary in 2010 as a political project. Independent institutions are political, rather ironically. That's better than my country. We haven't even started. Because we have not come to the realization that independent institutions are political. The first people who came to that realization were our politicians. And I like to tell lawyers and activists and teachers, you know what? Learn from the politicians. They are the people who know where the dead bodies are buried. They understand that judicial independence is political. So they want to have something political against everybody who is appointed to the judiciary. I mean, last year in my country, we appointed a bunch of very senior judges. I went to meet up with the head of the Economic and Financial Crimes Commission as this was going on. Supreme Court, 11 justices, Court of Appeals, 16, Federal High Court, 23. And I went to meet with him and have a private conversation. I presume this is, I know this is being recorded, but I presume this is still Chatham House rules. And one-on-one inside his office, and I asked him some questions. He said, my brother, honestly, I investigated them. And the night before they were sworn in, because all of them have to be appointed by the president, I took my report to the president. He looked at it, he read the summary, and he flipped through the pages, and he stood up and he hugged me. He thanked me very much. He took the report and put it inside his drawer. And he told me, of all of those people, none of them cleared financial credibility tests. You know what that means? When the administration needs a judge to do them a favor, they'll bring out the report and they will say, you see, your name is here. And if you don't oblige them, it's used against you. The politicians understand what independence means. Do we, as advocates, understand what independence means? Are we looking enough at the examples of the politicians and learning for the purposes of what we need to do to hold our institutions to account? And the third issue I want to raise is a structural approach to independence. We teach when we do that independence is achieved once we have these four things, right? The judiciary is funded independently. Appointment and removal is addressed by Judicial Service Commission or an independent institution. Remuneration is such that judges don't die in office and they can afford have decent existence. And then those are essentially the three basic things. We don't even address institutional cultures. But you can have all of those things and still have your judiciary captured, and that's exactly what is happening in most of our countries. You can have proper appointment, great salaries, and have proper funding, and still have captured judiciaries. So what is the problem? How do we get institutions peopled by appointees who actually understand what independence means? And here I want to tie up both regional or extra-national institutions as well as national judicial institutions. and is the note on which I want to bring my remarks to a close. Last week, the African Commission on Human and People's Rights, the chairperson of the African Commission on Human and People's Rights, issued a letter of congratulation to Paul Biya on his, in quotes, resounding victory in the presidential election in Cameroon. And this was, the letter was dated the 7th of October, 27th of October, 2025. Do you know the date on which the Cameroonian Constitutional Council announced the results? 27th of October. The letter was issued within 10 minutes of the Constitutional Council of Cameroon announcing the result. That announcement came 3 days after the constitutional time limit for the Cameroonian Constitutional Council to issue the result. So it came out of time. I'm not even talking about the dispute, nor am I talking about the number of people who died as a result of the elections. But the important thing is that the African Commission on Human and People's Rights is the continental institution charged with adjudicating complaints on these kinds of issues, including elections. And so if a Cameroonian has complaints about those elections now, and they cannot get remedies before their national courts, where do they go to? As we are talking about that, in 2020, after the 2020 elections, Saif Sharif Ahmad contacted me because there was no lawyer in Tanzania who felt safe enough to go to represent any of the parties in Tanzania. Saif contacted me, the heavens bless his soul, and requested that I represent them in a case before the African Court on the electoral process in Tanzania. As you well know, in Tanzania, once results are announced, you cannot go to court over them. We went to the African Court. We've been in court since 2020. This is 2025. On the 26th, Tanzania filed a defense. Tanzania entered appearance. On the 26th of June, on the 21st of June, the African Court issued a release that it will announce its judgment on the 26th of June. 24th of June, 2 days before that date, Tanzania applied to the court to arrest the judgment. No sensible reasons given. The court obliged them, the judgment is arrested, and all the issues that have been flagged in all of the election observer reports, including the SADC EOM and the AU EOM, which some of you may have heard, are up for this decision in this case that the African Court has arrested. The immediate past chair of the African Court is a Tanzanian judge, and she installed the current chair. Now, I'm not making any allegations here, I'm just stating the facts as they are. The question is, what are we prepared to do to get independent institutions, both nationally and continentally? I yield.
Let me first preface this. I did sort of just 3 case studies outside Africa, just to show what's happening in other jurisdictions, but the complexity of these issues. To this question, my remarks, I think, would be more geared to the situation in Kenya, because I would want to make clear that I identify fully with the comments or the opening remarks that Professor Deche made in the context of Kenya. Because I think this place, and as Professor Chibi says, this country has had so much potential when it comes to judicial independence and judiciary, growing judiciary, both as a legal institution, but more importantly as a political institution. But we are squandering that every day. And we are squandering that especially at the level of Judicial Service Commission, because Judicial Service Commission thinks it's a trade union for judges. and its role is to protect judges regardless of whether or not the allegations being made against them are well-founded or not. And in fact, as indicated with an illustration, almost subterfuge. That's one level. And I worry, Commissioner Deche, that by judges thinking that they are protecting each other, they forget they are destroying the institution, and ultimately they are destroying themselves. Judicial Service Commission has a very, can have very creative tools, or can get very creative tools on how to enforce judicial accountability. I've talked to some of the sitting commissioners now, and I've asked, what is so wrong about running, for example, a lifestyle audit on judges? What's so controversial about that? And JSC doesn't have to be the only body. There are a lot of technical experts who can help it and who can help it do this and be able to bring the confidence that panelists were talking about in terms of judicial accountability and credibility. What's so difficult about setting a mechanism to do that? What is so difficult about the fact that it's patently clear when judges deal with private law matters, some judges, and by the way, we have very, very good judges, and I recognize that. We really do have good judges in Kenya. And Professor Chidi, I'll say this. I've actually said we're doing a disservice to this country, even in terms of judicial jurisprudence marketing, because the jurisprudence that is being churned out of Kenya, and at all levels of court, whether it's at the Environment and Land Court, at the Labor Court, at Court of Appeal, at the Supreme Court, some of the jurisprudence is so groundbreaking. And we have to own that, and we have to be proud of that. And we are not doing enough, because again, we get trapped into this pettiness of people don't want to be accountable when they are asked to be accountable. So that's one of my problems. I feel there is an honest conversation, Commissioner Deche. I know your term is over and you did a stellar job when you were there, but I know you are peer. There's really an honest conversation that needs to be had from at the level of the Chief Justice and all the commissioners, that they need to protect the institution, not the judges first. You protect the judges by protecting the institution. But the second point before I end, let's be honest. At the same time, there is witch hunting of judiciary is a business model by some lawyers. And we have to agree to that. There are lawyers who've actually come up with a business model that you witch hunt the judiciary, and part of that is you be seen by the public that you're the most intimidating. Clients will come to you because when you go before a judge, the judge will have to give you orders because they fear you're gonna call them out. And law society and bar associations are failing because it's also for the bar associations to protect judges from unnecessary witch hunt. We shouldn't be allowing lawyers to just be making wild, unsubstantiated claims all the time, and nobody's calling them out. Not the law society, not our bar association, because people are untouchable or what? So let's be fair. Let's also be fair to judges. When I think about the judges you spoke about, Commissioner Deche, who are just stuck there and they can't speak for themselves. And luckily, yes, law society did a lot, then civil society did a lot, but we also have a responsibility as bar association to make sure that we are professional in terms of also how we deal with these issues. Again, we are destroying the institution because the talk now becomes about the corruption of the Kenyan judiciary. And it's true, there is corruption in the Kenyan judiciary. But that should not also foreshadow all the good things that are happening. And it shouldn't be a reason why the bad apples, or those who want to protect the bad apples in the judiciary, are able to justify why they have to get these sort of quick protective orders.
The issue of judges filing cases at the High Court. Dr. Deche talked about the Supreme Court judges. I'm involved in that. This is one of the most difficult of things for us who are litigating, and particularly for the High Court, because the Judicial Service Commission has merely asked the judges of the Supreme Court to respond to petitions. Why don't they allow the Supreme Court, the Judicial Service Commission, to make a determination, and if they're aggrieved, challenge the decisions of the JSC? Because we have a constitutional principle called the principle of subsidiarity that will require that the JSC creates its own laws and principles. So why are the judges of the Supreme Court so quick to file petitions barring the JSC from doing its work? Then we have this strange animal, and I'd want to hear you work on this: decisional independence. Decisional independence. Decisional independence is bandied like a carte blanche, ticket to do anything that you want. The last time I checked, John Finnis, inventing decisional independence in 1995, did not envisage decisional independence to be a ticket to commit all manner of atrocities and not be asked questions. So it boils down to the conduct of individual judges. Who are you? Because your character is what you do when everybody is not looking. Who are these that we are bringing to the bench? Because you cannot make decisions. The other day we had a judge who made a decision that led to somebody committing suicide. What did you do with this particular jail? Simple slip on the wrist, but the person died. And then we were told that's decisional independence. And then we were met with the usual arrogance. Accountability is a sister to judicial independence.
Firstly, when we are speaking of judicial independence, are we looking at institutional independence of the judiciary as an institution, or we are also looking at individual independence of the judges constituting the judiciary? And linked to that, I wanted to find out about the institutional dynamics, particularly on the role that is played by the Judicial Services Commissions. For example, in Zimbabwe, where a magistrate or judiciary takes a stance or a decision that is not favored by the mainstream Judicial Service Commission, they end up getting transferred to remote stations, for example. How does such a practice affect judicial independence, more so when it's coming from the administrative body of the judiciary itself?
One of the things that we keep doing in Kenya for the last many years is that at a political level, we cannot agree on too many things, on most things actually. So then what is happening is that we throw all those difficulties, all those things that we cannot agree on, to the judiciary. So actually then we expect the judiciary to make decisions. So, whether it's about elections, so every single election, the petition, and then so many other issues. I think what I keep wondering is, does there reach a point where actually the backbone of the judiciary breaks? Because we can't resolve things which we think would be obvious at a political level. So we always have to go and seek judicial arbitration. And so is that then part of the problem when now we are discussing or figuring how we ensure that our judiciary can continue being accountable? And then quickly, Chidi, obviously I cannot speak for, and it's funny, I cannot speak for the African Commission. So since I've been out of the Commission for many years now. But I'm wondering whether there is a point to nuance. So that, for example, when you look at the mandate, the Article 45 mandate of the African Commission, it's rather diverse. So you have the promotive function, you have the protective function. And so, for example, the narrow technical question which you asked around remedy would come under the communications procedure, which then in that sense would be distinct, for example, from the promotional procedure. Possibly, I suspect, under which the chair might think they could issue that sort of statement. But of course, as you point out, then there are all those other details. So I'm wondering, in terms then of the African institutional framework, are we then saying that possibly the framework itself is problematic? Are we looking then for a situation where you then have an institution which only focuses on the protective mandate, which then is what happened when the African Court was established, at least in respect of the African Court? Because I would still argue that you can have this formula where you have an institution with the promotive mandate, but also with protective mandate, so long then as you are smart and judicious in terms of how you deal with those mandates.
I would like you to comment on the aspect of safety of judges, knowing that in most jurisdictions, judges get protection from the executive. And of course, there have been a few cases where they get calls and they're told, we know where you live, we know where your family members are. So how do you ensure the balance of the fact that judicial officers rely on the executive for their safety? And are there examples, maybe we can draw from our history, whereby we never had a scenario judges needed to be afforded protection, but they would just live within community, be independent in rendering their judgments?
To something Professor Chidi said on the rule of law and the story he gave us on Carl Peters. And I just wanted to remind us that here in Kenya, during Moi's time, and even during Kenyatta's rule, both governments comfortably used the Preservation of Public Order Act, which was a colonial law, and the sedition law and the Chiefs Act, and they used them against Kenyans the same way. Like, you use negative laws, it is the rule of law, but you are detaining people without trial for years. You are jailing people for speaking out, for reading books, for singing songs, for things like those. So it is not lost. It is not just what was happening in 1980, 70 something you say that, but even today, given a small opportunity, governments still use laws that are negative to discriminate or to oppress their own citizens. So, and in Kenya just recently, and even now, I think it's being used, because if I hear the comment from my brother here about what the Africa Commission, that statement should not be issued irrespective of whether I don't know what you're trying to argue there, but should such a statement on Biya be issued congratulating him, irrespective of the conditions we are in Africa? Such a statement should not be issued. So are we saying that there are spaces that we can get away with statements like those? There are spaces we can get away with abuse of the rule of law, because the law exists, you just use it against your people. Anyway, it's just a comment. Thank you.
Principle of decision on independence, which I also struggle with, especially in the context of how it is applied by the Kenyan JSC. And Dr. Deche, you may want to speak on this. One of the grounds for removal of a judge under Article 168 is incompetence. Now, incompetence, my understanding, goes into how you perform your duty, your role. And the main role of a judge is that of judging. Now, where do we find this other than by looking at the decision of the judge, and that is in your judgment to make. That is where we find your competence and incompetence. Largely, that is the role of the judge. Now, why would the Kenyan JSC be so reluctant when it comes to looking at the decisions that judges have made, when that becomes a ground for removal by the judge? Merely because you can appeal. The fact you have a right to appeal does not take away the incompetence that is apparent in the decision that a judge has made, assuming it's a court of appeal or a high court that you can still challenge. So that's the point I would want you to display.
Okay, thank you so much. That was working for the Judicial Service Commission, was acting for them in a matter in which they had issued a letter of reprimand against some Supreme Court judges. And I found myself with the unenviable task of having to cross-examine a Supreme Court judge before a High Court judge, which we did for a few hours. And at the end of the process or the exercise, the High Court judge ruled, one, that the Judicial Service Commission can only deal with matters of gross misconduct. And matters of misconduct, if they don't rise to the level of gross misconduct, are beyond the scope of the Judicial Service Commission. And secondly, my observation, because I've acted for JSC in a number of cases in Kenya, is exactly what you said, Dr. Deche, that there is a tendency for judges to rush to the High Court the moment they receive a letter from JSC asking them to respond to a certain complaint. And then they get conservatory orders on an interim basis that stonewall the process of inquiry from the Judicial Service Commission. And those orders can be enforced for years. And there is a sense in which there is almost like a collegiality, an informal collegiality between the judge who's being investigated and the trial judge who's now dealing with the case. It seems to me that the Constitution had intended to have these processes done by Judicial Service Commission, that as judges, representatives of LSK, as well as the AG and a few other people that compose the Judicial Service Commission. Now to my questions. Now that we're in the state we are in right now, and these questions are addressed to Dr. Deche, although the other panelists may answer. Number one, what is the way out of the current situation where there is already a finding that misconduct is not something that should be handled by JSC? So who should deal with matters of misconduct? And how do you deal with them? Because you don't want to wait until you reach such heavy grounds for removal of a judge or judicial officer. We are discussing accountability, but you want to have a system where you can deal even with ordinary misconduct cases. And of course, the High Court was saying that judicial independence is important, and so judges should be insulated from petty, could say, complaints against them. But there could be cases of misconduct. That's the first question. And the second question is, now that JSC in Kenya at least is gradually being treated like a subordinate court or inferior tribunal, where you can have a decision made by, JSC has like 5 judicial officers there, or judges representing the judiciary, not representing the judiciary, but from the judiciary. The CJ, a judge from the Supreme Court, Court of Appeal, High Court, and a magistrate. Those are 5. Then you have the Attorney General, you have the 2 representatives of LSK. So you have very senior lawyers and judges there. But their decision is treated like a tribunal, or one-person tribunal decision that can be very closely looked at by a High Court judge, although the outcome of JSC is meant to go to the Supreme Court. So how do we deal practically from where we are with the tendency of a single judge to treat the processes of this Judicial Service Commission like an inferior tribunal that can be stopped, can be directed on anything, and therefore to forestall scrutiny that can lead to accountability of the judiciary. What is the way forward? As LSK, the Law Society of Kenya, or other bar associations in the continent, how do we deal practically with this situation? Thank you.
I hear a lot about decisional independence. I'll leave that to professors. And especially the contradiction that Evans Uganda was bringing up. But I just wanted to make one quick comment in relation to comment that Professor Mute raised, which is overburdening the judiciary with a lot of cases. And this comment was also made from here in terms of using the judiciary as the opposition. I think it's what Professor Deche said is so fundamental, and as a society we have to think about it, because we are actually also breaking the judiciary by overburdening it. And part of that overburdening is also happening at the Attorney General's level, because there are a lot of cases that, for example, come up where the Attorney General should just yield and ask to be allowed to settle the case out of court, because most of the time the Attorney General loses, especially these very controversial political cases. You don't expose your institution to that level, but I guess there is instructions to take from Professor Chidi that the politicians understand the politics of judicial independence better, and this is partly their strategy to break the judiciary. Your specific question, Commissioner Mute, was what to do, or how do you get out of that? And I think it's a really difficult question even for judiciary. One thing I would like people to look at, there is a very good book by a South African, The Nix Rules. The last name is R-O-U-X. And it's the politics of principle. And he tries to answer how the South African court, the South African Constitutional Court, the first court, really tried to balance the issues of politics and law without losing legitimacy. And I feel that is a big problem for us, and I'm not sure our judiciary, and especially the Supreme Court, really appreciates how to do that. And it's both with politicians, but in Kenya it's also with Kenyans, as we saw with the finance bill litigation.
First of all, to Mute's point, just continuing from where Wiper stopped about overburdening the judiciary, I'll say two things to that. One is, this is about demand and supply. There is nothing like, in my view, respectfully, sir, there is nothing like overburdening the judiciary, because that is demand. The fact that you make a demand does not mean that you're going to be guaranteed supply. The judiciary has the capacity to say no. And there are doctrinal devices all over the world through which the judiciary filters what it decides and what it doesn't decide. In my own country, secondly, the judiciary is happy to be overburdened in this way because it creates a market for collecting. All right? Now, we did amend the Constitution in 2007 to preclude certain appeals from going to the Supreme Court so that they could focus on things that mattered. The Supreme Court justices were mad. You know why? Because it made the Court of Appeal justices richer. And so they set aside the constitutional amendment and said they wanted to be overburdened. So these people here complaining about overburdening the judiciary, are you sure? That's the question I want to. Have you spoken to the judiciary? Are they telling you they're overburdened? That's all I would ask about that. No. But a judiciary that wants to deal with that has always got doctrine for dealing with it, and that's never been an issue. Now, the question about safety of, I'll probably come to the question about safety of judges last. But to the question about the African Commission, I think it's so wonderful to see my younger sister here, Jerry. I think the question has been dealt with by Jerry. I don't want to. I don't think it's important to flog that issue, overflog it, and therefore the question that the senior counsel asks Kajama, what I take away from it, and I'm not going to get into the territory that you posed for Dr. Deche. What I take away from it is all of us are victims of trauma. There is a trauma when we confront the judiciary and misbehavior of judges, because we are all indoctrinated, post-colonial victims. We are all indoctrinated into thinking judges are gods. And we cannot, because you're saying you had the challenge of cross-examining a judge, and every one of us suffers from that issue of trying to hold a judge accountable for things we would not suffer from if that person happened to be a politician or any other person. I think we've got to humanize judges. We cannot talk about judicial independence and continue to treat judges as gods. They are just human beings who can be as flawed as any of us, subject to the same problems, subject to the same pressures, who can do good and do bad and do evil and do terrible things and do virtuous things. And I think that comes down to the pedagogical challenge I was talking about, and now to mentorship challenge. How do we bring along the younger people to understand that judges are human beings? And in trying to therefore address judicial accountability, how do we change our mindsets in the political context in which we find ourselves of building accountable institutions? How do we encourage citizens to address them in the same manner? I think we do have a social psychology and institutional psychology problem we've got to break down and overcome. I want to pose that here as an issue. Finally, to the question about safety. As the chair of the Nigerian National Human Rights Commission, I enjoyed the trappings of judicial office and tenure. And at a point in 2013, I was facing all manner of challenges. And I had to go to the president directly because there was no other person who could address it. And I went to the Nigerian president and I told him my issues. And he sent me to the senior most security and intelligence official in the country. And we had a meeting. And he basically presented me with a protection plan. And the president's instruction was straightforward. Give him any protection he requires. And I was presented with a protection plan that was going to make me the second most protected person in Nigeria after the Nigerian president. I told him no. I could not in good conscience accept it. And he looked at me and said, young man, do you understand what you're saying? I said, I totally understand what I'm saying. But I cannot accept it, because if I say I'm accepting this, that basically means I'm no longer up to my job. So you know what, I'll take my chances. And he's a very good Muslim. So I told him, are you a person of faith? He said yes. I said, okay, sir, let's pray over this and leave it at this. If what I'm doing is of God, God will protect me. If it is not of God, he will strike me down. No amount of protection you give me will help me. I said, are you sure? I said, yes, sir. And I left. But you know the interesting thing? After that, my protection was in the hands of the people. And I got senior military officers willing to lay their lives down for me. I had the senior-most levels of the police protecting me for free. I never applied to any of them to protect me. For 12 years, I lived under armed protection provided by different people. Why do I say this? Because ultimately, the biggest guarantor of your protection is the quality of your work. That's the first thing. Till date, I travel around Nigeria and people protect me. I have a lot of problems in Nigeria, but from the time I land at the airport, immigration officers who see the manifest will come and meet me. I have never met them before. Till date, I just came from Nigeria 2 weeks ago. And customs officers will rush me through customs. Taxi drivers who take me from the airport and refuse to accept money. Till date. And now I offer the money, they refuse. The point I'm making is, if you are a crooked public servant, nothing can protect you. And I will end on this note. 30 years ago, he was executed by the Nigerian government. His name, Ken Saro-Wiwa, the environmentalist. I was a lawyer for Ken, and in the last appointment we had, Ken told me something. He said, Odikalu, what kills is not talking from the center of the mouth, it is eating from both sides of the mouth. Please, if you want to live long, don't eat from both sides of the mouth. I will yield.
Just mention 2 or 3 things. Self-insulation, where do we go from here? And someone asked, what's the way out? I have a very dim picture of how things will end. We are looking at an implosion. You know, you can only push people so far. And that's what happened before we had the vetting. Because if you shut all the doors where people are supposed to express themselves, that's what I think, and I never hesitate to tell judges and magistrates that just shut all the doors. You know, the power belongs to the people in our constitution. It's been all the arms of government exercise power on behalf of the people. And there is a way, it's Judge Muchelule, when he was in the commission, kept reminding us, we are exercising power here on behalf of the people, and one of these days they'll walk in, they can walk in through those gates. I see that. My prism or glass crystal ball tells me that that's where we are heading, so help them God. And it's true, it can only destroy the institution, not make it stronger. Decisional independence, it is a problem, and it's dicey. If you want JSC to now wade into those waters, and I'm not saying that there are no judges who just come up with very ridiculous decisions and hide behind decisional independence, but there is also another door that we do not want to open. When I was at the commission, there were people, especially commissioners who were appointed by government, who had a problem with Justice Odunga. You remember he was in the constitutional division, and you know, in that division you're always making orders against the duty bearer in human rights issues and constitutional issues, and they always used to say, why should he be saying this? Maybe we should do this. And then remember the composition of the JSC. We have people who are not lawyers. Do you want them to be sitting over deciding over decisions of judges and magistrates? Yeah, we have presidential appointees. How much leeway do we want to give them? Remember, we shall revisit in 2017. That was also all about decisional independence. There was a time we had that issue concerning a court, one of the courts of equal status that was notorious. You can guess which one it is, for just issuing ridiculous orders. And what Professor Githu told us when he was AG is that, yes, we can use the path of incompetence, as my brother here has said, but incompetence, there's a decision to that effect, must be demonstrated by a pattern. You don't want a judge to make a decision one day and then you say, oh, this one is incompetent. So he was proposing a kind of an audit, so that then we can look at, we can now have someone removed on the ground of incompetence. Then Kanjama was asking, what do we do concerning these infractions that do not meet the threshold of gross misconduct? I think we should force all of them we should call all of them gross misconduct. What is in a name? Yeah. And you know what happened? In that particular one, actually the Supreme Court judges had gone on strike. They had put their pens down. We are not going to continue working if so and so is, I think it was all about retirement or something of the sort. So for me, the reason why they said it was misconduct was because the CJ Mutunga was about to retire, and that other judge. So there was going to be a problem of quorum if we sent all the judges home. And of course, people are also very, very scared. That's the time I joined the commission and I met a group of very terrified people. I can say that for free because I'm no longer there. So the chief registrar was told, send them that letter and reprimand them. Even nobody wanted to sign that letter. So I think what should happen is that all of them should be classified as gross misconduct, and then the JSC can comfortably handle them. But there is also room for administrative intervention by the head of the judiciary. I remember Chief Justice Gisheru used to be very firm on that. He would summon judges and ask them, what is this I've had? So that's what I would say about that. Finally, you said we give our parting shots.
Sorry, before the parting shots.
Do you have his permission?
The judiciary supervising, single judge supervising JSC.
Oh, about single judges supervising JSC, what stops them? You see, these people have original jurisdiction. What are we saying about what the High Court can or cannot do? And remember, Supreme Court only comes in not to supervise or to intervene in a decision of the JSC, but it is with regard to the decision of tribunals, isn't it? Yes. The tribunal that is ultimately appointed by the head of state. It's not the decision of the JSC. So there's nothing wrong with that. I do not think that the High Court should be gagged because again, are we saying that the JSC is special or sacred? So we should not have sacred cows. That again will open another dangerous door. I hope that is okay. Of course, that's what I'm saying. We are now heading at an implosion because everything that they are doing is within the law. It's provided for by the law. You can go to court, you can stop a process, you can have a conservatory order. Yeah. So the way I see this issue of accountability, I long for the time when we'll have the kind of accountability that we demand of a pilot. I know most of you flew to this place, unless you are like me. I don't live far from here. But you know, when you board a plane, you know 99.9% you are getting to your destination. But what happens when you are engaging the court? When you are filing a case in court, you don't have that confidence. So I long for the days, I look forward to the days when we will have the confidence that we normally have in a pilot when it comes to the judiciary, and I hope it's in our lifetime.
I think we started off with judicial independence, like she says, and we sort of like balanced the water. And we were comfortable thinking, now we know judicial independence, we know what we expect. Yes, there's challenges, yes, the water, and then suddenly the water got cold, because now we had to account as judges. Also, judges are no longer God. So we can actually take, I think that is what we're struggling with. The cold water. Everybody's struggling with it. Judges are struggling with it. Lawyers are struggling with it. The JSC is struggling with it because, as she says, the other horse is in the stable, but reined it, but can escape. We shouldn't let it go. But here's another horse. Accountability. And I think different jurisdictions are beginning to realize that this is another horse that we have to deal with. But the horse is not in the stable yet. The question is it still wild? Can we ride on it? What are we doing with this horse? I think this is the stage where we're at infancy, development. Some are ahead, some are still struggling. Some don't even have a code of conduct. We just had a code of conduct in May 2025. So it's a moving horse, and I like the engagements because they say so many perspectives, so many things. From a judicial point of view, we're scared. We know that we're not God. We know that we can be removed. How we react? Personal conscience. We have a conscience, guys. Well, at least some of us. This judiciary that goes through this public interviews, different type of judiciary. Because by the time you get to the interviews, you have been investigated by the secret security. I don't know whether it happens here. In my country, the secret security investigates you. The GCO investigates you. The RSL taxman investigates you, everybody knows about you. You're basically naked. So by the time you go to the public interview, you're like that king who's parading naked and thinking that you're dressed. So if you've gone through that process and you've earned the trust and confidence of your society, I wonder if as a judge, any judge, myself included, would be stupid enough to risk that. I mean, if you applied for a job, it means that you want this job. Maybe we go with different perspective, but I think that when people go there, they go there with good intentions. I could be romanticizing it. But the thing about judicial accountability is that it is the horse that is now doing the races. Sometimes it's going to win the race, sometimes it's going to be slow. It's like Devon July. But let's bet on this horse, because it is the horse that is going to balance the water in the shower, so that when it gets cold, we know that there's accountability. When it gets hot, we know that maybe independence we have to get the balance, the two sides of the coin. So my take home is that the judiciary is up to the task. Yes, you'll have incidences like the judiciary self-protecting, because suddenly you're going to lose your job. Suddenly you realize that I've messed up. What am I going to do? Can my colleagues protect me? You start realizing that you're human. You start saying, hey, Nzame. To your colleagues, are they going to zama you? I would never zama anybody who would not. I can say this, and I think most of my colleagues would say that. We're not in the zamming, we're not mazama. We are there to administer justice. And it's a personal choice that we all have to make. Like he said, there was corruption in heaven. There'll be corruption here. But we pray and we hope that at least the judiciary will be held accountable. Thank you.